Good morning, everyone, and thank you for joining us today at today's webinar on the Irish ILP, your questions answered in 30 minutes. I'll hand you over to my colleague, Stuart Frost. Thank you, Stuart.
Thank you. Good morning. Next slide, please. So we're going to start our conversation. Both myself and my partner, Raj Tandon from Foley & Lardner, will start our conversation by using the hypothetical of a direct debt fund. This because the direct debt fund creates the most complex set of challenges, and will illustrate just how neatly the ILP can be utilized quickly in a highly challenging environment from a tax perspective. So we'll go to the first tax slide, please, then the next slide. So we need to introduce a few concepts to explain the nature of the hypothetical that we want to discuss today. And the first tax term that we want to introduce you to is what we call ECI, or effectively connected income. Now, the US concept of when it's going to impose tax on a offshore investment vehicle looks to the question of whether or not there's income effectively connected with the conduct of a trade or business in the United States. This is effectively connected income. And ECI is essentially the concept of income realized from a business in the United States. And this particularly is of concern for direct debt funds, whereas it would not be for hedge funds or UCITS. Raj, why is a loan origination fund particularly a problem in this context?
Yeah, so thanks for that, Stuart. So, one would think that, hey, this is sort of an investment fund, and typically, say, with a private equity fund or a VC fund, venture capital fund, that the foreign investors are passive, and so their income should be passive, which by and large means no U.S. tax. However, under our Treasury regulations, making loans to the public is considered to produce effectively connected income. And until about 12 years ago, there at least was sort of the argument that while a fund is still, perhaps not making loans to the public, a credit fund, there was a question of whether the U.S. sponsor will be viewed as an agent and cause this. But arguments could be made that perhaps the sponsor doesn't taint the fund with this ECI making loans to the public, even though the agent may be essentially viewed as in the loan origination business and therefore making loans to the public. In 2009, the IRS came out with guidance that essentially stated that a private credit fund is viewed as in the loan origination business through the U.S. sponsor, who was viewed as an agent under our Internal Revenue Code. And then a few years later, the IRS came out with similar guidance. So the IRS's view is pretty clear here that a credit fund, debt fund, is viewed as producing ECI under our Internal Revenue Code. Next slide, please. Right. So what does it mean that the credit fund is producing ECI? Well, that means that ECI is passing through to the investors of that fund, and they have to file U.S. tax returns just like U.S. residents. So each of them has to file a U.S. federal income tax return. Most foreign persons don't want to do that. They have to pay tax on that effectively connected income, just like U.S. residents. So if it's an individual, they have to pay tax at up to a 37% rate. If they're a corporation, it's a 21% rate. And also the U.S. payor has to withhold on ECI. And in addition, in all likelihood, there'll be U.S. state and local taxes as well. So, and compliance obligations. So, you're looking at, substantial tax and compliance burdens. In addition, if you have a foreign corporation investing in the fund and they realize ECI, they're subject to a special branch profits tax. The reason for the branch profits tax is essentially to equate a foreign corporation that's conducting a business in the United States to a foreign person that is conducting business through a corporate subsidiary and remitting dividends to that foreign corporation, which is, or foreign person, foreign investor, that attracts withholding tax. However, the branch profits tax is incredibly complex, and most typically it's going to attract taxes higher than if you operated through a corporate subsidiary, and it's a 30% rate that could be reduced under treaty. So it's a pretty steep tax, and so a lot of complexities in compliance and obviously tax if you're realizing ECI. However, I guess our hope here is that we can rely on tax treaties to minimize that U.S. tax leakage, and the tax treaties override the Internal Revenue Code. And in this regard, if we have a good treaty, say that reduces withholding on interest here to zero, and we're comfortable that the U.S. sponsor qualifies as an independent agent under that applicable treaty, which is a defined term, then we can eliminate all of those adverse tax consequences. Because if the U.S. sponsor is an independent agent, it doesn't taint that fund with effectively a U.S. trade or business, which produces ECI. Under the treaties, that's called permanent establishment income, or income attributable to a permanent establishment. But we basically get to the same place, eliminating ECI on that income. Next slide, please.
So in this context, we'll be looking at two types of treaties, country-specific treaties, and Ireland will be our primary focus, of course. And also, side by side, we'll look at investor-specific treaties. Investor-specific treaties are sometimes what we call bring your own treaty structures. And in that context, we look to the residence of the investor and the state of domicile of that investor and the U.S. tax treaty with that investor. But Raj, what factors do we consider when we're looking at tax treaties?
Well, the two principal factors that we look at is its legal independence and economic independence, and this is all based on this case that came out at this point 25 years ago, Taizai Fire and Marine, where the tax court concluded that a U.S. agent could be an independent agent and therefore not taint its foreign principles with ECI or permanent establishment income. And under the treaties, and as elaborated in that case, essentially there are what this means is that for legal independence, the agent has to have full discretion to essentially do what it feels is best on behalf of the foreign principal, and economic independence, that the agent is not essentially economically dependent on that principal. And people have different views on what this means, but full discretion essentially means that you're not looking for approval to the foreign principal for whatever it is you're doing. You can operate within guidelines, but you're not looking for approval. And economic independence is that essentially, if you lost this principle, you're not going to file for bankruptcy. And Taizai kind of talks about that. In that case, essentially the four principals each sort of produce 25% of the income for the U.S. principal, and that wasn't viewed as producing economic dependence. And the IRS has its own views about independent agency. And so we typically want to meet both. We want to meet the Taizai standard, and we want to meet the IRS's factors if we can. Next slide, please. So this slide goes through a fund treaty structure that we use quite often. And here we're often using an Irish ICAV, or Irish Collective Asset Management Vehicle. ICAVs qualify as residents explicitly under the U.S. Irish double tax treaty. And as long as, looking through sort of all the chains here, at least 50% or more of the investors are U.S. residents, we can meet the limitation of benefits provision under the treaty, and then say pretty definitively that the Irish ICAF can qualify for benefits under the treaty. And if our US sponsor is a independent agent, that agent isn't going to taint the fund with PE income or ECI. And so we don't have to worry about loan origination conducted through this ICAV. And we can set up feeder funds on behalf of specific investors to do certain things. For example, for US investors, we can have a pass-through structure all the way up the chain. For our US tax-exempt investors, we can set up a Cayman vehicle, or now the new Irish limited partnership. We can check that closed for US tax purposes and therefore block unrelated business taxable income, say if the fund is using leverage, and also any compliance obligations. That's good, obviously, for our tax-exempt investors. And nonetheless, we can look through to those investors for meeting that 50% test. And for our other foreign investors, we can set up a special ICAV feeder, or we can set up the new Irish limited partnership, and we can block ECI for those investors. Also, for those foreign investors in the EU, we can passport that vehicle to meet sort of EU security standards under AIFMD. Next slide, please.
Thank you, Raj. So this next structure is a little bit more straightforward, and you can see the ILP here. The ILP can serve as either a feeder fund, or it could be the loan originator itself. The critical thing here from a tax treaty perspective is that we achieve fiscal transparency of the structures all the way down the chain, from the originated loans to sometimes we introduce a master fund here that would be fiscally transparent. The ILP itself would be structured, shown here as a rectangle, as a tax blocker for the reasons that Raj alluded to previously, so that there would be no obligation on foreign investors to participate in any US tax compliance obligations, although in reliance on their treaties, there would be no tax burden actually paid, but there still are tax filing obligations. So we typically would have the ILP feeder check closed, as Raj mentioned in the prior structure. But here we're looking at the very top of the structure at good treaty country investors, countries like Germany or the UK or the Nordic countries, where you'll find very favorable tax treaties with the United States. And so long as we have fiscal transparency in those countries throughout the chain, the investors can rely on the treaties that they've brought from their country to claim benefits under the treaty and not be subject to ECI or the branch profits tax. Next slide, please.
Well, let me just elaborate on 2 points there. It's kind of counterintuitive, but despite the fact that we can check that feeder fund to be closed for US tax purposes, nonetheless, we can look through that fund, that feeder fund, to the foreign investors to rely on their treaty benefits. So we sort of win on both counts. We check it closed and we eliminate the compliance obligations, and nonetheless we can look through. But always, we have to confirm that our US sponsor is an independent agent. That's always critical.
So now, if I may, on the final slide that we'll present, let's talk about the ILP in this context. So one of the things that we like about the ILP is that it's easy to form. It has no particular capital requirements. It looks a lot like a Cayman or Delaware limited partnership by the time you're done building it out, which can make, despite the fact that we might have multiple feeders, or we might have one feeder, in either case, we can make these ILPs look very, very familiar to US and international investors. We can establish an umbrella structure if we want to, using our ILP to support multiple investment structures and be protected under Irish law from contagion risk. And one of the key benefits here is that the Irish limited partnership does not have legal personality. And because it doesn't have legal personality, in other words, the general partner has legal personality, because the limited partnership itself doesn't have legal personality, it's highly likely to be viewed as fiscally transparent in a bring your own treaty structure, and of course is viewed as fiscally transparent in Ireland. Raj, any other considerations?
Yeah, so as I mentioned before, we can check that feeder fund to be closed either under the bring your own treaty structure or the fund treaty structure. And that means that, to the extent there is any compliance, it's at the feeder fund. Technically, the feeder fund does have to file a US federal income tax return. It doesn't pay anything on it most typically, but it does have to file that return. There will likely be some state and local tax filings. Treaty benefits don't apply to the states, so there'll probably be some state and local taxes, some state and local tax filings. That's all done at the blocker level, the feeder fund level. It's not done at the investor level. That's hugely attractive to most foreign investors. And also, there may be some ECI in some circumstances. You invest in a U.S. real property holding corporation, you have a workout. Workouts could generate ECI, it just depends on the facts. Doesn't necessarily will generate ECI, it just could. And again, there may be some tax, but we're avoiding the U.S. compliance obligations that might otherwise apply to that ECI. Stuart, do you want to talk about passports?
Exactly. So one of the great things about the ILP is that because it is based in Ireland, it is passport eligible so long as the master fund meets the requirements of AIFMD, or so long as it's the master fund itself. And so we have a vehicle that's super flexible. It can plug very easily into Irish tax treaty. It can plug very easily into bring your own treaty structures. It can be used as a feeder fund that looks like all the other feeder funds in your structure, from whether it be Delaware or Cayman. And so arguably, if not, the ILP introduces what we think of as perhaps the best feeder fund ever. Very standard looking from the perspective of an Anglo-American investor, with incredible flexibility and passport eligible. Next slide, please.
Thanks, Stuart and Raj. So over the next couple of slides, myself and my tax partner, David Lawless, will give you an overview of the key features of the Investment Limited Partnership in Ireland, the features of the qualifying investor fund, which is the regulatory category that most ILPs set up in Ireland will fall into, the process of establishing one of these fund vehicles in Ireland, and only David will cover the Irish tax features of these funds. Next slide, please. So this structure chart represents a basic single ILP structure. And of course, these structures can have a lot more complexity, and they can include feeder funds and master funds, underlying funds of funds, and all sorts of acquisition vehicles. But this, I think, gives you a good idea of the basic features. So as Stuart has alluded to, it's an Irish regulated fund. It's regulated by the Central Bank of Ireland. There's no option to have an unregulated Irish ILP. It's regulated under a dedicated piece of legislation, the Investment Limited Partnerships Act 1994, which was recently amended. And it falls under the AIFMD regime in Europe, which is important for passporting, and there are other considerations which I'll allude to in a minute. As Stuart said, it may be formed from a structural point of view, it may be formed as an umbrella, and that's highlighted because that, as far as I'm aware, is not available in Luxembourg. Other than that, from a structural point of view, it's aligned with international features and international partnerships, and is quite flexible from a structural point of view. It can be a retail AIF, but mostly these funds are expected to be established as qualifying investor AIFs, and our next slide will describe what's involved in those funds. EU passport eligible, which is a very significant feature of these types of funds. Once you appoint an EU authorized AIFM, then the ability to passport the fund to professional investors around the European Economic Area is ensured. The general partner can be Irish, doesn't have to be, can be EU, can be non-EU. It must have a board of directors, so you're talking about a company. Generally it will be a limited company, but doesn't have to be. The directors have to be pre-approved by the Central Bank of Ireland, but the entity itself doesn't have to be regulated anywhere. It's not subject to any sort of regulatory approval process in Ireland or elsewhere. The GP has to appoint a local depository and an administrator. And that's really a feature of AIFMD, but that's it as regards local service providers. It needs to be audited once a year by an Irish statutory auditor, but everything else from the AIFM to the GP, to the distributor, to the investment manager can be established outside of Ireland. The AIFM can manage the fund directly, or it can appoint an investment manager delegate to do so. So in the case of a US investment manager looking to establish an ILP and looking to have the European passport, typically you will hire a third-party AIFM, or you may have an AIFM in Europe within your own group, and then the US investment manager would be appointed by the AIFM as its delegate. The AIFM can distribute the fund if there's a distribution feature needed, or it can appoint agents to do so. Next slide, please. So the qualifying investor fund, as I mentioned, this is the regulatory category that most of these ILPs will fall under. It is characterized by having a €100,000 minimum investor commitment, 500,000 for certain types of funds, specifically a feeder fund that invests into an unregulated fund. The investors themselves, they actually don't have to have any real characteristics. There's no wealth test. It's a self-certified investment, but investors that fall into the category of professional investors as defined under European law can automatically invest. Otherwise, it's a self-certification as to experience and expertise and knowledge. At the portfolio level, qualifying investor funds don't have any diversification or concentration restrictions. There are some rules around fund of funds and feeder fund strategies, and specifically, if an ILP wanted to invest in an unregulated fund, it's on a feeder basis. It's possible once the minimum subscription per investor is €500,000 and subject to certain disclosure requirements. And bearing in mind, if an EU AIF that wants to be passport eligible wants that passport to remain in place, it has to restrict its investment in a single non-EU fund to 85% of its net asset value. Other than that, there's no borrowing or leverage restrictions generally, except in the case of a loan origination fund. So the Central Bank of Ireland's non-bank lending rules are reasonably restrictive compared to other jurisdictions, but you do get the benefit of a highly regulated fund. Many managers are not going to consider these requirements to be onerous or too restrictive, but the principal features of the regulation are it's a single asset class fund, it's loans, debt instruments, or credit instruments primarily. The fund has to be closed-ended with a fixed term, eligible borrowers only, so no financial institutions or funds or individuals. There's a 25% borrower group diversification requirement until the end of the, which applies at the end of the ramp-up period, and you can define your own ramp-up period. There's no restrictions in that regard. And the leverage is 1-to-1, so it's 200% of net asset value. Lending funds have to have an EU authorized AIFM, and funds that require the passport for marketing in Europe have to have an EU authorized AIFM. If you have an EU authorized AIFM, then certain European laws are going to be triggered, including rules under AIFMD regarding acquiring control over certain European companies. The Shareholder Rights Directive, SFDR, which people will be very familiar with as it recently came into being, and the Securitization Regulation. Next slide, please. The authorization process for one of these funds, as I mentioned, they're regulated by the Central Bank of Ireland. They require a license. They must apply to get that license. Generally speaking, it's a 24-hour self-certified process. So you file your regulatory application, which comprises various regulatory forms, a letter of application, and then the fund documentation, which would be the prospectus, the LPA, an AIFM agreement, investment management agreement, if there is a separate investment manager to the AIFM, an administration agreement, and a depository agreement. The 24-hour process applies almost to every application, but there are some funds to which it doesn't apply, and a lengthier authorization process is required. And that is largely where there are investment strategies which the central bank is giving particular attention to at the time. At the moment, those include lending funds, funds that invest in real estate, life settlements, and other asset classes of that nature. The appointment of a non-discretionary investment advisor is something that triggers one of these lengthier authorization processes at the moment, but we're hopeful that that process will not be around for very much longer. To get access to the 24-hour process, there are certain preconditions that need to be met by the fund, and specifically that the general partner directors must be pre-approved already by the central bank, and that the core service providers, being the AIFM, the investment manager, if there is one, the administrator, and the depository, must also have been pre-cleared or approved by the Central Bank of Ireland. And I think we're over to you, David. Next slide, please.
Okay, thank you, Danica. Just very quickly, just on the Irish tax transparency, it's relatively simple. From an Irish income and capital gains tax perspective, it's specifically provided for in Irish tax legislation that the ILP is tax transparent. Essentially, that means that all income gains and losses of the ILP are allocated among the partners based on the partnership agreement. So we just follow the commercial agreements and what's agreed between the parties. The only exception to that rule is if there's any unallocated profits or losses. Can't see the circumstances in which that may arise, but if there was, the Irish tax legislation basically provides that any such unallocated profits or losses will be deemed to belong to the GP. So essentially, from an Irish perspective, we're recognizing that the ILP doesn't really exist from a tax perspective when it comes to income and capital gains taxes, and it's like as if the LPs had invested in the underlying assets directly. Next slide, please. So for those who are familiar with Irish opaque funds, how they quickly differ between an ILP is that typically with opaque funds, in order to make a distribution to non-residents, you have to obtain a non-resident declaration from investors in order to make distributions free of Irish withholding tax, or IUT as it's often called. For ILPs, because effectively they don't exist for tax purposes, there is no withholding tax restrictions there. We don't have to obtain any declarations from investors. And the ILP does have to make a tax return to the Irish Revenue every year, basically showing the names, addresses of the LPs and how income and gains are allocated among them. That's really effectively to capture information in relation to any Irish ILPs. Assignments of LP interests are free from Irish stamp duty, just like the assignments of shares or units in an Irish opaque fund. And then probably one important point is that while an ILP is tax transparent from an Irish income and capital gains tax perspective, it's not tax transparent from a VAT perspective. But the normal VAT exemptions which apply to Irish opaque funds, such as VAT exemptions for fund management fees, depository, fund administration fees, equally apply to an ILP. And just again, from an Irish perspective, ILPs are treated the same as Irish opaque funds, both from a FATCA and CRS purpose. I think I'm over to Jason now. Next slide.
Thanks, David. So what I'll do is I'll just run through the requirements of an AIFM as they relate to a direct lending fund, given that that's the focus of the webinar. And many of these points have been made already. So firstly, the AIFM that's appointed can either be a non-EU entity, and in that case, it would generally be the investment manager of the ILP, or it can be an EU authorized AIFM. Now, there are advantages to having an EU authorized AIFM, and I'll get to those shortly. If it is EU authorized, it's responsible for the management and administration of the fund of the ILP in this case. So effectively what that means is it's responsible for all of the compliance and regulatory obligations of the fund. So we'll very much be facing the regulator in terms of any questioning around the fund. And importantly, the AIFM will also provide all of the initial and ongoing oversight of all the various service providers. So in this case, it would be the investment manager, the administrator, the distributor, the custodian, depository, and so on. In the case where we're looking at ILPs, an EU AIFM must be appointed. So again, it's responsible, the AIFM itself here will be responsible for ensuring compliance with the central bank's opaque requirements and rules, as Donica had pointed out earlier. And an EU authorized AIFM, having appointed one, will also allow for the marketing passport across Europe to professional investors, whereas the non-EU AIFM does not. The AIFM itself is appointed by the GP, and as is standard practice, can delegate investment management back to the regulated investment manager. And that investment manager can either be EU-based or non-EU based.
Thank you all very much, and I'd like to thank each of the panelists. We very much look forward to making use of the Irish Limited Partnership in our fund formation structures. We're quite confident that we'll be using it in private equity and venture capital and hedge fund structures. And we've demonstrated, we think, that it can be especially useful in the most complicated setting, which of course is our direct debt environment. And with that, we think the ILP will really be a boon to US fund managers as they contemplate accessing global markets. And thank you all very much.
That's great. Thank you very much to all of our panelists today. For the attendees, for any of you that raised a question during today's webinar, I'm afraid we're up against the time constraints for this specific webinar, but we will be delighted to answer any questions directly post-webinar. Following today's presentation, we will be furnishing you all with a copy of the replay together with today's presentation. Thank you everyone for joining.